Hey everyone, today I'm going to be talking a little bit about competency to stand trial. Competency evaluations are one of the most common types of forensic evaluations or forensic services that forensic psychologists offer. The research shows that there are about 60,000 competency evaluations conducted in the United States every year. And so you can see that it's something that a lot of forensic psychologists are involved in. By the end of this lecture, I hope you understand a little bit more about what the courts mean when they are asking whether someone is competent or incompetent to stand trial. I'm hoping that by the end of the lecture, you understand that competency is a legal concept and not a psychological one. We'll also talk a little bit about the Dusky case and how that sets the precedent for our assessments of adjudicative competence. And then I also want you to have some understanding of how an individual's functioning relates to their adjudicative competence. And then finally, we'll look at some hypothetical situations to assess whether or not you believe an individual lacks the capacity to assist in their defense. Okay, so as we go through this lecture, I want you to be thinking for a few minutes about the skills that you would need to be able to help represent yourself in court. Let's imagine that you were charged with a murder and you were going to trial. What sort of skills do you think it would take to mount an effective legal defense? You don't probably have a law degree, so how can you help your attorney represent yourself? And how could your skills be impacted if you had some sort of serious mental illness or an intellectual disability? These are the kinds of things that we'll be sort of talking about in this lecture. Okay, so as I mentioned earlier, competency evaluations are fairly common. About 60,000 defendants are evaluated every year for competency to stand trial, and only about 25% of those people are found to be incompetent. People who tend to be found incompetent often have histories of mental illness. They may have histories of drug abuse, and they may have other kind of psychological issues. That by itself wouldn't render somebody incompetent, but if those impairments negatively affect their ability to work with their attorney or to understand what happens in court, then they could be deemed incompetent. Okay, so I want to make sure that I'm clear about the fact that competency to stand trial is a legal concept, not a psychological concept. We as psychologists don't have any sort of diagnosis that says someone is competent or incompetent. Typically, what we do as psychologists is to determine whether someone has some sort of mental illness that might interfere with their competency-related abilities. So just remember that competence is not a psychological concept. Also remember that competency involves your capacity or your ability to do the things necessary to assist in your defense. In other words, you may not necessarily have all the skills you need at the time you meet with your attorney, but the question is, can you develop those skills as you work with your attorney? So, for example, I may not understand all aspects of a plea agreement, but do I have the the underlying intellectual ability and the appropriate psychological functioning to be able to do and learn these things from my attorney to work with him or her. So it's a legal issue, not a psychological one, and it's about your underlying ability rather than whether you have all of the skills necessary to be able to represent yourself. Okay. Our current understanding of competency is related to the Dusky case that was decided by the Supreme Court. And in the Dusky case, the courts looked at a number of different factors that must be present in order for an individual to be deemed competent. Simply having a mental status that is looking okay to your attorney does not mean that you're competent. You have to be able to have a factual understanding of what's happening in court. So do you understand the charges against you, the potential punishment you could get, those kinds of things. you have to have a rational understanding of what's happening. So can I use the factual information that I have to make reasonable decisions on my own behalf? And then finally, can I use the information that I have to consult with my attorney to be able to mount a successful defense? Okay, so I have to have all those skills in order to be deemed competent. And I want to make it clear that competency is related to a defendant's functioning at the time of the trial rather than at the time that the crime was committed. So some people get confused sometimes and they think, well, competency is the same as insanity, and those two things are distinct, and we'll talk about those as we go forward. Just remember that for a defendant to be found competent, they typically have to have these three prongs of a factual and rational understanding of the proceedings, and then to be able to consult with counsel. Typically, when the courts raise a concern about an individual's competency to stand trial, it happens before really any of the trial proceedings take place. Usually it'll happen at a pre-trial hearing where a defense attorney meets with their client and they go, oh wow, this person looks like they may have some sort of mental illness that will interfere with their ability to help me. And they may, that attorney may ask the judge to order a competency evaluation to determine whether that individual should proceed. If an individual looks fine in the beginning of the pretrial hearings, they may still be asked to do a competency evaluation if they start to exhibit deficits in their ability to assist. I've been involved in cases where an individual looks competent at the outset of their legal proceedings, and then they may end up developing psychotic symptoms or something over the course of the trial. They have to stop that trial and then do a competency evaluation to determine whether that defendant is able to continue to proceed. Really, it's a pretty low threshold to ask the courts to order a competency evaluation. So at any point when one of the parties involved has concerns about whether the defendant is competent to stand trial, then the judge will typically order a competency evaluation. I've actually been involved in a case where a judge ordered a competency evaluation for an individual, not necessarily because he was actively psychotic or had intellectual disabilities, but he was convinced that he was going to represent himself in a case that involved multiple rapes, and he was looking at hundreds of years in prison if he were to be convicted. In that case, the judge wanted a competency evaluation to make sure that if he were to go through representing himself and he were to be found guilty, that the courts couldn't be, the decision couldn't be overturned by the appellate level courts if he were to be found convicted, because he was looking at a significant amount of time if he were to be convicted. As forensic psychologists, when we conduct competency evaluations, after the court has ordered us to do so, we typically interview the defendant. We may administer some sorts of psychological tests. These aren't common unless we have some serious concerns about intellectual disability. Usually the test that you'll see most often is some sort of IQ test. As part of our evaluation, we may also review the defendant's history to see if they have any kind of psychiatric issues or if they had any kind of educational problems that might suggest some sort of psychotic process or intellectual disability. Once we've done those things and we've kind of come up with our opinion, we write our report and we submit that report to the court. And then typically that is kind of where it ends. If there is any kind of question about the psychologist's opinion, sometimes the psychologist will be asked to come in and testify in court as part of a competency hearing. I generally try to write my reports in such a way that I don't have to go to court because I hate testifying. But sometimes you can't really avoid it just because there may be multiple psychologists involved who have differing opinions and the judge wants to hear testimony about the different evaluators' opinions. These evaluations can be conducted on an outpatient basis, meaning that rather than having the defendant admitted to a hospital, they may be conducted in the jail, or they may, if the person is out on bond, they may be evaluated at the psychologist's office or at the defense attorney's office. At other times, we may do these evaluations in an inpatient setting if the person is really, really sick, has the potential to be pretty violent, or needs to be observed for possible malingering, which we'll talk about here in just a second. Okay, so as part of our evaluations as forensic psychologists, we always want to be aware of the likelihood that somebody is faking a mental illness in order to avoid being prosecuted for their offense. When we talk about malingering, that's sort of the fancy term for faking or exaggerating mental health symptoms in order to avoid punishment or to get some sort of external incentive or goal. You may not wish to admit it, but all of us have probably engaged in some sort of malingering at some point in our lives. I can honestly say that I have pretended to be sick at times to avoid going to class or to avoid other kinds of things. I may have, rather than wanting to be sitting in class, I may have wanted to go out and hang out on a nice spring day rather than sitting in a cooped up classroom. So think about in your own life, you may be guilty of malingering or exaggerating, a sore throat or something like that to avoid consequences. Potential negative situation like going to class. In forensic evaluations, the stakes are a bit higher than if we were to skip class or, call out from work. We're typically talking about someone who could avoid months or years in prison. And if they were to be found incompetent and to not be adjudicated for their offenses, the victim also sort of has that justice taken away from them to see some sort of retribution or punishment for the person who committed the offense. So we always want to make sure we're paying attention to the possibility that the defendant we're evaluating is being forthright and honest about their symptoms. One of the challenges in assessing malingering is that it's often difficult to detect. We have to look at how the individual presents to us during our evaluation and then compare that functioning to their overall lives. I had a case one time where an individual came to me and pretended to have significant intellectual deficits. They tested out with a 40 IQ, which, if you know anything about IQ tests, a 40 is really, really low. That's a person who probably needs to be in some sort of group home or in a setting where they need constant help to kind of interact with others and take care of themselves, bathe themselves, feed themselves, that kind of stuff. This particular individual, although he tested out with an IQ of 40, drove to the evaluation in a really nice blinged out Cadillac Escalade. Drove himself there, didn't have anybody with him, found his way to my office, and it was in a place that he didn't know anything about. So, I essentially just told the guy, your IQ says that you should be in a group home, but you obviously are doing better than that. And I was able to kind of say, well, I think you're exaggerating your intellectual deficits just based on what I was able to observe and combine that with the testing that I had done. Sometimes people are much more successful at malingering, and we may have to have them admitted to the hospital to determine, through repeated observation, whether they are actually as intellectually impaired or psychiatrically impaired as they may present during our initial evaluation. I had another case where an individual pretended to be intellectually disabled, and we sent him to the hospital because I had some concerns that he was faking his intellectual disability. While he was at the hospital, staff noticed that he was able to read some pretty complicated books and that he was able to play chess with other patients who were on the unit and was able to beat those opponents most of the time. So we, through our observation of him, ultimately decided that he was malingering, and we told the courts that he should probably go back and be tried for his offense. If we do our evaluations and we opine or give an opinion that the individual is incompetent to stand trial, then what should we do with that person? The question is, once they're incompetent, do we drop charges? How should we handle them going forward? The courts are reluctant to drop charges when individuals are found to be incompetent. And so typically what we do is we try to decide what is going on with this individual that makes him incompetent. And then we try to figure out if we can treat that symptom or set of symptoms in order to restore them to competency. Okay, because we want to balance the rights of the defendant, but also the rights of the community. We don't want to just let the guy go if he's incompetent, but we also don't want to, send him to trial and have him locked up if he is truly incompetent. So we have to sort of balance those two needs. Typically for the folks that we see who are found to be incompetent, they have some sort of significant psychiatric symptoms. They're typically psychotic. They may have a bipolar disorder or schizophrenia, possibly depression with psychotic symptoms. There's a video that I've attached to this lecture that kind of shows what Andrea Yates looked like when she was charged with murdering her 5 children. And if you watch that video, you can kind of hear some of the psychotic symptoms that she was experiencing as a function of her postpartum depression. If we think that somebody needs to be treated medically for their mental illness to restore them to competency, we'll often have them admitted to a hospital. And we'll kind of administer medications and see if those medications start to help relieve their symptoms. If they sit in the hospital for a significant amount of time and they don't appear to be getting any better, what we're supposed to do is go back to the courts and say, look, we don't think this individual will ever be restored to competency. And at that point, the judge has to decide, are we going to dismiss the charges? Are we going to have this individual be, have their charges dropped, but have them civilly committed to the hospital for treatment if they're a danger to themselves or others? Those are some of the issues that the judge has to kind of wrestle with to decide what is going to happen with an incompetent individual. While these individuals are in the hospital, they may get, as I said, psychiatric treatment that includes medications. Sometimes those medications may be injectable medications if they have trouble taking their medications as they're supposed to. We may also educate them about the court system, so teach them what the judge does, what the jury does, those kinds of things. Sometimes the use of antipsychotic medication can be controversial because some defendants don't want to be prescribed medication. And then there are other attorneys who feel like if the defendant is medicated for their psychiatric illness against their will, that you're essentially restoring them to competency so that they can be punished. And some civil liberties organizations feel like that is unfair for an individual to be involuntarily medicated to restore them to competency, because they can then face trial and be punished. So those are some of the issues with restoration of competency. If you have any questions about these things that I've discussed, please feel free to email or post in the discussion forum. The key things that I want you to make sure you take away from this are that competency is a legal concept, not a psychological one, and that just because you have a mental illness doesn't necessarily mean that you would be found incompetent to stand trial. If you can do the functional things that you need to, like understanding the charges against you, understanding the punishment that you could get, if you can converse and relate with your attorney in a way that is adequate for you to be able to assist yourself, then you may be able to be found competent even though you have some sort of mental illness. So those are some things that you want to keep in mind. Mental illness by itself does not equate to incompetency. Okay. Thanks for listening to this. Like I said, if you have any other questions or comments, please feel free to post them in the discussion board, and I look forward to hearing any questions you might have. Thanks.